unless you are invited to speak. Please keep your camera off unless requested or if you are presenting. Also use the Q&A feature to submit your questions and we will address them during the Q&A session. This session will be recorded and it will last approximately 2 hours. We encourage you to stay for the entire session to gain most value. Please, if you experience any technical difficulties, use the chat box to notify us. It's my pleasure to invite Gordon Myers, ISLP's Head of Responsible Technology Practice, for opening remarks. Gordon, the floor is yours.
Thank you, Gloria, and thanks again to the East Africa Law Society for working with us to convene this last of our 4 sessions on navigating legal disputes in the digital age. We began some weeks ago with a deep dive into AI and digital advocacy before we turned our focus to cybersecurity and data protection. Our 3rd session on technology and international arbitration drew together important global and regional insights on efficiency, fairness, and access to cross-border dispute resolution. We close our series today with an equally important final session on best practices in intellectual property. As in all our sessions, our goal today is to explore with you this important area of practice that is increasingly critical in the modern economy and to the East African development story in particular, both from a global perspective and within the East African context. For those who are new to these sessions or may not recall, I'm Gordon Myers, formerly Chief Counsel and Head Technology Business Risk for IFC, and presently head of ISLP's Responsible Technology Initiative. ISLP provides pro bono legal services in the emerging markets in partnership with organizations like EELS that have direct knowledge and expertise in their respective jurisdictions. RTI supports technology uptake to accomplish development goals and practitioner adoption of responsible technology practices. We prioritize working with trusted partners in the region like EELS who share our values and objectives. On behalf of ISLP, may I say what a privilege it has been to work with EELS to bring you this series of outstanding panels, and in the process to become acquainted with some of East Africa's own outstanding practitioners, such as Catherine and David. We are also indebted, of course, to our international practitioners like Bhumika and Andrea, who will be presenting today, who have given so generously of their time. And not least, we are grateful for the opportunity to work with Gabriel Achaya, our valued partner who heads professional development and membership for EELS. Finally, thanks also to Gloria and Rumbi of ISLP, on whom so much of this depends. Would you take a moment to give them a virtual hand? And finally, thanks to our audience for their attention and interest. I am pleased to say that over the course of our 4 sessions, we have had over 300 attendees from the region whose interest and engagement at this intersection of technology and justice has been the reason for this program's success. We hope to see all of you again soon. And with that, let me turn back to Gloria for the business at hand. Thank you.
Thank you so much, Gordon. Once again, a very warm welcome to you all. It's our pleasure to have such a diverse audience joining us from practitioners, scholars, policymakers, and technology experts. As we all know, the rapid evolution of artificial intelligence and digital technology has transformed nearly every aspect of our professional lives. The legal field is no exception. Today, we stand at the intersection of law, technology, and ethics, navigating questions that challenge traditional notions of authorship, ownership, and creativity. This session will explore how jurisdictions across the world are addressing emerging issues such as AI-generated content and copyright ownership, fair use and data training for large language models, and responsible integration of AI tools in legal practice and dispute resolution. We are particularly privileged to be joined by distinguished panelists who will share global best practices, regional practices, current legal debates, and practical insight on how AI is shaping intellectual property rights and administration of justice. In no particular order, we are joined by David Bahige Mutume, an advocate with over 6 years of experience, specializing in IP, data protection, AI governance. David is an associate at Trust Law Chambers in Rwanda and with experience at Uganda's Kampala Associated Advocates. He will offer unique dual jurisdiction perspective on the East African legal landscape. We are also joined by Catherine Kariuki Mulika, a leading fintech expert with a strong focus on data protection, IP, and payments. As a deputy chair of Intellectual Property Committee at the East Africa Law Society, she leverages extensive legal knowledge and experience as a certified data protection officer to provide strategic advisory services that drive regulatory compliance and business success. We are also joined by Bhumika Malik. Bhumika is a principal corporate counsel at Microsoft, specializing in product-related legal matters. With over 11 years of experience advising clients in technology sector, Bhumika brings deep expertise in digital platforms. We are also joined by Andrea Campbell. Andrea is a principal corporate counsel and commercial attorney with Microsoft South Africa. She provides legal support for enterprise and public sector customers across Africa with a focus on South Africa and MCC Africa markets. She specializes in technology law and advocates for responsible use of AI, helping organizations navigate complex regulatory landscapes while enabling digital transformation. So thank you for taking time to be here. We look forward to an engaging, insightful, and forward-looking conversation. Without further ado, it's my pleasure to introduce our first panelist, Bhumika. Bhumika, the floor is yours.
Thank you, Glory, and thank you for that kind introduction. Hi, everyone. I'm thrilled to speak to all of you on a very topical and pertinent topic of AI and copyright and the discourse that is shaping up across the globe on this particular issue. I just want to call out at the beginning that any of the opinions I express during this session are my personal opinion and they don't reflect the opinions of my present employer. And I'm also going to go off camera because that will help me focus better in delivering this piece of talk. Right. So it seems like yesterday that when Gen AI products hit the market, lawyers were speculating on the possible issues and impact on IPR rights, and in particular copyrights, as the use of AI increases in all walks of life. In a span of few months or possibly a year or so, while the issues and risks relating to AI and copyright are now more formalized and in more mainstream knowledge, yet a lot of clarity and finality is left to be achieved. Now, what is this debate in the AI and copyright space? Copyright, like you can imagine, has to do a lot with creative works and some special rights that are repose with a creator or owner of these creative works, and they enjoy some special rights with respect to the things that they create or the materials or the content that they create, right? Now, AI, and in particular generative AI, also deal with creative works. And they deal with creative works at both ends of the spectrum. When I say both ends of the spectrum, what I mean by that is when an AI system is built, it's built on top of creative works. So that's where the first interface of copyright and AI comes in, right? And then ultimately when the end user uses an AI system, they are looking to use these AI systems, in particular generative AI systems, to create, again, creative works, some work where there's human inputs involved. So at all stages of developing an AI system, there is an interface with copyright. And that's exactly where some of the areas of debate emerge from. So as you can see on the slide, I'm going to focus on some of the broader themes of these questions which are emerging in AI and copyright area. They they range from fundamental questions of authorship, ownership, originality, and fair use when generative AI is used by the users. Now, the first area of debate: who owns AI generated works? Most jurisdictions mandate in the copyright regime or laws that a human author is eligible to hold copyrights in copyrightable works. Be it the US, UK, India, Hong Kong, you pick up any jurisdiction, you pick up any copyright law in these jurisdictions, the requirement of a copyright existence or copyright ownership has to be in a human author or in a human who has made arrangements for the creation of the copyrightable work. So that goes on to say that most of the laws only recognize human authors as eligible copyright owners. Any work that's created out of machines, the author cannot be a machine. A copyright cannot vest in a machine. So now when the jurisprudence is that there must be a human author in the fray, right? Who is this rightful human author to have the copyright ownership when there are multiple entities involved? You have your AI developer, you have an organization which is developing AIs, then you have your prompt engineer or the person who's inputting prompts into an AI system to generate an output. You also have an organization which may be taking services from the AI system provider. So there are multiple human actors involved. Who really owns the copyright in an AI generated work? That's the first area of debate that we have. Another raging area of debate on AI and copyright is whether AI generated works are original or not. As you may know, the fundamental requirement of most copyright regimes is that there needs to be human creativity involved in the underlying works. So if a machine is trained on vast amounts of pre-existing data and it starts producing outputs, can it qualify as a human creative work? Most of the cases or the litigations that we are seeing in this space are deliberating on this issue. US, for example, US Copyright Office's guidance or Court of Justice in EU, all of these offices, they emphasize that human creative arrangement is a mandate and must lie in an AI assisted work for due copyright protection. So this debate has to be settled whether AI generated work is actually a machine output or is it a human output. Then thirdly, another very important area of deliberation that's open right now is application of the copyright law to training of AI systems. On one hand, developers of AI systems argue that AI outputs are transformative enough to qualify as fair use. This argument is opposed by alleging that AI works are verbatim copies of the training data and thus they substitute the original works, and that's why they cannot fall in the fair use exception that is accepted in a lot of markets. The verdict is, like I was mentioning, is divided on this issue, and I'll be talking about some of the case laws which have emerged in this area. For example, in 2023, a US court rejected training of AI systems on pre-existing data to be fair use, but a very recent US case again has given a contrary opinion to that. They have accepted fair use as being an exception to training AI systems. And lastly, again, it's kind of overlaps with the earlier points that I made. Do AI outputs infringe on the training data that the AI system is trained on? I mean, is it only a regurgitation of the training data that the AI system is fed on, or does the AI system actually apply something more in order to output something that gives something of value as in response to the question or the prompt asked to it? So I think these are some of the broad areas where questions are open. There's a lot of opinions being put forth from both sides of the coin. And time will probably settle the dust around these issues, and we'll have maybe more definitive jurisprudence emerging in the coming times. I would like to move to the next slide where I talk about some of the legislations or the current status of legislations across the world that touch upon this AI and copyright debate. It's clear to the lawmakers that traditional IP regime is insufficient to cover the debates emerging from these emerging technologies. Hence, many jurisdictions are revamping their IP laws, and there's an increasing trend seen between balancing innovation and IP protection. For instance, in US, their Copyright Office has issued guidance on the expectation of human authorship, and the courts have multiple high-profile litigations pending before them where the fair use principle is being examined like never before. But the needle on specific legislation within US to quell this debate has not really moved. But then there are other jurisdictions like Japan, Singapore. There are specific recognition for text and data mining when it comes to fair use exception. What this means is that if an AI system has scraped certain data sources for training its AI systems, that's a justifiable ground to use pre-existing IP. So, as like I mentioned, the reality that innovation is happening and happening at a very fast pace, that's something lawmakers and policymakers are increasingly adopting. Is just that there's a homogeneous regime on this particular issue is yet to be seen, and that's something that we should be on the lookout for. Now moving very quickly and to an associated topic to legislation is the litigation scenario in this particular space, right? So the next slide talks about what are some of the cases which have emerged when debating the place of copyright in AI systems, right? Without going into specifics of each of the cases, I would like to focus on some of the recent and most I would say, significant cases that have come from different jurisdictions, where I can also demonstrate probably different approaches being taken by jurisdictions when approaching the same question of law. For instance, in very recent cases in US, for example, in Thaler versus Perlmutter, it was categorically ruled that only human authored content can be copyrightable. However, in China, in a case which is, you can see from the table, Tencent versus Yungzhen, I think the court broadened their view. They were open to the fact that AI can be an author of a work, provided, there is some human intervention in terms of how the output has come to be, right? There's a prompt or there are some policies that an organization is following when the AI is generating some output. So you see, two jurisdictions have taken slightly different overview and approach to the same question as to can human authorship be overruled in an AI output. Similarly, another example of fragmented opinion on this debate can be seen within US itself, where a couple of years back in Thomson Reuters versus Ross, which is an IBM product, training of Ross on pre-existing data was not considered as fair use exception because the court was of the opinion that by creating this AI system, which is trained on legal case summaries or is fed with legal case summaries, a substitute product is being created, thereby falling out of the fair use exception. But again, in US itself, very recently in a case against Anthropic, which is the owner of Claude, AI system, the court has accepted training on pre-existing data to be fair use. So there's a lot of emerging jurisprudence on these questions, and there's definitely a lot of interest when resolving all of these questions, right? Now, I would like to go to the next slide where which is probably the most important aspect for us as lawyers to consider when guiding our clients on what AI systems should be used, right? Now, we are aware of all these debates that are existing, all these open questions that exist. How do we navigate in such uncertain times in a way where our clients don't land in legal troubles, right? There are some ways which we can adopt, which shows clean intentions on our part, which establishes fair practices and will probably give indication to regulators or litigators that our intention is only innovation and not really violation of existing IP rights of third parties, right? So first is obviously taking care that human authorship is at the center of any AI output that you or your organization or your clients are considering in developing, right? Till the time the dust settles on whether AI is allowed to be or AI is considered to be an author of a copyrightable work, it's always good to demonstrate that human intervention was there, and that's why it's indeed a copyrightable work. It's not a machine-only authored work. Secondly, I think very importantly, careful approach to use of third-party data when developing AI systems. Till the time, again, the debate on whether training on pre-existing data is fair use or not, we have to be careful about third-party data that's being used to train AI models. Do we have the right or sufficient rights to train on third-party data? Are there any restrictions that the third-party author has levied? Is paywall being broken to access data? I think all of these are very important considerations when advising on what data sets are okay to use to train your AI models and what are not okay to use. I think, again, a subset of using of third-party data is also respecting author autonomy. I think this is mostly seen in areas of data scraping or data mining on the internet. I think one of the ways where authors of websites or authors of content or webmasters, like they are known, they indicate in their HTML files whether or not they would allow or they are open to third-party systems, AI systems scraping their content. If your clients are finding these tags present in those websites, best to avoid these websites for training your AI systems, right? And at the center of it all is, all of these efforts are centered towards building a responsible, safe, and trusted AI model. We have to have, and I'm talking about AI governance also in my last slide, we have to have strong AI processes, strong AI reviews, strong AI systems in place when we are developing these AI models and these AI user interfaces. Because I think the way the filters, the way the meta prompts of these AI models are designed, they go a long way in ensuring that harmful content or violative content is not produced by the AI systems. Lastly, I think a very important area is also how privacy and AI are interfacing with each other. If you have an AI system that you are trying to build, sell, or market, it's very important that the AI system is not built upon personal data of personal data subjects, and also the AI system is not producing outputs where personal data of unrelated data subjects is involved. So all of these again become a part of building a responsible AI system. My colleague Andrea will also be talking about live use cases where we demonstrate how a responsible AI system is built and how it operates. And it'll be a good demonstration just after I finish. I would like to probably end my talk with some of the other emerging trends in the AI space. They are not necessarily centered around copyright, but this is something that all of us probably will be seeing, if not already seeing, in our work with AI systems is AI and digital safety. There are multiple jurisdictions which are taking digital safety extremely seriously. In UK, we have the Online Safety Act. In Australia, we have the Online Safety Act. The more and more AI is being used for our digital interactions, the more and more the regulators are becoming concerned about issues like deep fakes, issues like fake content generated by AI, which look pretty real. What about safety, digital safety of minors and teens who are now using all of these AI systems in a very native manner? So I think AI and digital safety is going to see a lot of focus from regulators and will keep us lawyers very busy in the coming days. And also AI governance, like I was talking about and I was emphasizing on the importance of building robust AI systems. Just like data governance saw a lot of focus when privacy laws were becoming mature in the last few years, as AI laws also become mature, the expectation from regulators would be to build processes which build responsible AI systems and also demonstrate when required and keep on record sufficient documentation that we have indeed built responsible and safe AI systems for all. So I think this was my piece on talking about some of the debates that surround AI, copyright, digital safety. And with this, I'll probably hand over to Andrea.
Thanks so much. I just want to make sure I'm going to be able to slide. So I think I'm going to shift the focus and talk about why responsible AI is important, how we look at it at Microsoft, how we've approached it with regards to our foundational models, and you've heard Bhumika talk about how models have been trained, what data they've been used to train on, and I'd like to share more on why we followed this approach, why it's important, especially in the legal field, for us to consider that, and then some of the ways that using technology and specifically our Copilot can help us within the legal space to sort of pivot and to, deliver justice more swiftly, but also ensure that there's more accuracy and reduction in risk. So if we can move to the next slide. So at Microsoft, when we talk about responsible AI, for us, it looks like referring to the 6 principles which we've adopted. It's not something that's new to us, but these principles align very closely to the OECD principles, which governments globally also follow, which is seen as best practice. I think there are over 50 odd countries which have signed up to this, and they map pretty closely. It also maps very closely to a lot of the legislation you would see across different jurisdictions that's coming up, whether it's in terms of self-regulation or whether it's in terms of actively, governing or legislating how models would work. We focus on AI being fair. It has to be reliable and safe. It has to be private, secure. It has to be inclusive, but then with a big focus on the transparency and definitely accountability. And those 6 principles for us at Microsoft, we've gone and we've filtered down to our corporate standard. So in terms of the requirements, the goals, the practices that we have as an organization, but also when we approach developing our foundational models. So that would be our Copilot or our, Azure, if you look at it. It also speaks to how we go about implementing processes, training tools, and then definitely the oversight, the monitoring, the reporting, and the auditing. And that goes to ensuring that we have this correct security, the safety in place as well in terms of the model, to safeguard against things like threat actors or threat attacks, against deep fakes, against, or what we'd say or refer to as bad actors as well, influencing or hallucinations as well. If we can slide. So the safeguards that we have in the undertakings that we give you from a Microsoft perspective when you are using our tech stack or our AI models is that your data remains your data. We don't have visibility into your data. We're not using it to train or enrich our foundational models. So we don't take any of the information that you have within the model and better or train on those. Your data and AI models are protected at every step. Those are by ways, I'll share those as well with you on the next slide, by putting security measures in place. We have our Secure Future initiative as well. We have data loss prevention in terms of tools like Purview. And then obviously what we have as well, and we were the first to market with this, we're currently still the only ones in market that give this undertaking. It's our customer copyright commitment. So if you're using any of our paid for Copilot applications and there are IP claims which are made against you while using the output, we stand in your stead and we protect you or we defend you for 100% of that claim without any reciprocal undertaking needed from you at all. This is, we've had this in place since September 2023. This is the confidence we have in the model and the output that's generated as well because of the way that our model, our foundational model is built, the information that it's trained on, and those responsible AI principles, which I've shared with you, ensuring that all output is an independent thought that is formed. It's not using any copyrighted material. It's not plagiarizing anyone else's work. And it's also cited. So any output has source reference and links, which you can go back on, you can check, but also you're giving credit to the author or the piece of work that you are using in terms of the output. The caveat is that you should not be amending any of the output, not even moving a comma. There should be no jailbreaks in place. So there's a whole list which is applicable to this, but definitely that we give this commitment to anyone using our technology. Next slide, please. What sets our Copilot apart, before I move into the demo pieces, and what I'd like to perhaps just shine a spotlight on, is that it connects to all of the Microsoft M365 applications. Some of the examples are your emails, your Teams, your Loops, your Notes, your OneDrive, your Share Drives, any of the other applications such as PowerPoint, Excel, etc. It links to those, and it links to the web as well. So it brings all of your work and your business data together across one application. It's integrated into all of the tools so you can use it seamlessly, and I'll show you in some of the examples how you use it seamlessly. It's new AI-powered search is integrated with the chat that we have, and it has 80 connectors, so you are easily able to layer any of your Copilot on top of any of your applications. For example, any of your legal journals or legal reports, any of the statute platforms that you use. I know throughout Africa, which would be popular would be AfriWise, LexisNexis, for example. You have applications such as Harvey, which is built on Azure, also, which is one of the connectors that you can add as well. It has advanced reasoning and work agents. So what that does is it's with the advanced reasoning, it works across all of your work and your business data, and it acts as sort of virtual employees gathering all of the information for you. We have a platform for agents which is low and no code, so you don't have to be a techie. The likes of the legal community are able to use the technology to pivot. For one, building agents seamlessly across your work without having to understand having the technical knowledge or having to understand the technical background. And then we have the robust security management and measures in place, which automatically reports instantaneously if there are any threat actors in your environment, if there are any hallucinations, if there are any jailbreak attempts as well within your organization. So you have a way of protecting your organization internally, but it protects your organization externally as well. If we move to the next slide. So we've seen a lot of news around just how AI is impacting the legal community and the judiciary as well, how it expedites delivery of justice, how it's helping, I know, specific judicial systems such as Nigeria to digitize their legacy law cases, but also help move swiftly through the legal and the justice system, court cases, helping with legal judgments, helping with transcription as well. We have similar reports within New York, within Brazil, so globally. There are lots of instances and examples where the innovation is actually helping drive productivity, but also helping expedite justice, which is one of the things that we've historically had a lot of, I think, challenges around. I'll share with you a few of those examples if we move to the next slide. So we've seen recurring themes, and at Microsoft, we work a lot with customers. Specifically in the legal community, we listen to what some of the pain points are, what some of the recurring themes are in terms of how they can use AI, but they would like to also use AI to alleviate, but to also pivot in how they're working and how they're supporting. So large volume of cases and data, you know, using AI to get on top of that, the complexity and the diversity of the issues. One, for example, is I support throughout Africa. I mean, it's many jurisdictions, 54 countries. There is a lot to cover. Having the understanding is sometimes very challenging, but also having the knowledge is, you'd sometimes find you have gaps. With AI, it allows you to pivot, but also it allows you to have the bandwidth or create the bandwidth to support larger jurisdictions, larger complexity of issues, but also to narrow your gap in terms of what business needs and in terms of the resources that you have as a legal team or as legal counsel, and helps you close that quite seamlessly, especially if you're layering it on top of different connectors, but also if you are using it in terms of creating agents to automate a certain workflows. It's evolving the legal landscape. We have seen, we've seen some positive and negatives in terms of how it's evolving the legal landscape. But the most relevant feedback I've received is from law firms using it to help pivot in terms of drafting and in terms of how they are supporting their caseloads, maintaining quality and efficiency as well. We did a closed study at Microsoft about 2 and a bit years ago when we started adopting Copilot within our legal team. And what we found was we gave some individuals Copilot and we didn't give others Copilot to summarize new case law, to prepare case files and caseloads in order to brief outside counsel for civil litigation. With that, we found that those that had Copilot were completing tasks 32% faster than those that didn't. But the biggest impact that we saw was those that did have Copilot found there was a 20% risk reduction in terms of the work that they were outputting. And that is a big number. I mean, if you can reduce the risk in terms of any work that you're supporting within your business, but also from a legal perspective in the judiciary system, it speaks volumes. If we can move to the next slide. So some of the use cases that we have is using AI, Copilot specifically, for the likes of legal research. And this goes across the legal community. It's not just for in-house, but those within the judiciary, those within law firms, in-house counsel, paralegals, etc. So legal research using case analysis, using it for case analysis, summarization of case laws, and then for legal drafting. And when we refer to legal drafting, this would be your initial drafts that you're using as well. We are finding a lot of firms are using it in the e-discovery process. And I just need to stop and pause and share that there's no replacement for the human oversight. So while there's a lot of speculation when we are talking about how we can leverage Gen AI within the legal community and within the different roles that we fill within the legal community, where we were previously perhaps the drafter or the individual sitting, pulling out all the journals, doing the legal research or doing the case analysis, sitting, actually reading the full case and then doing a summary. That has changed and we've pivoted. We now leveraging AI to do initial drafts, to do the case analysis. Where we then come in is being the individuals to ensure that there's human oversight, making sure the legal draft is accurate, that everything that is cited is up to date and is relevant. It's not stale, it's not been hallucinated, it's not fictitious. The case analysis is accurate and it's aligned to your understanding. Summarizations of case laws as well. And definitely with regards to legal research, using it to help you initially set out to find direction in terms of the research, to perhaps find or surface material or content which you didn't know where to find or was relevant to this legal research that you're doing. So while it doesn't replace us and our responsibility for checking and ensuring that everything that we are putting out as a body of work is accurate, it's aligned, and it's factually and legally correct, it does come in and helps us with that initial hard lifting and heavy admin based tasks. If we can move to the next slide. So here's just, I'm going to do two of these flows. The first flow would show you how you can leverage Copilot across different applications within the Microsoft stack to help you give quicker legal guidance. This could be in terms of any role that you currently sit in. So using Copilot to search for external and internal email could be across your emails. It could be across your chats. That could be your Teams chats and your SharePoint documentation. Copilot will only ever see what lives within your OneDrive, in your share points as well. That is information that is stored to a central drive. So everything outside of that, if it's saved to your PC, it won't have visibility. I just thought I'd add that so that you'd have that context. And then have Copilot, once you've asked it to look across your emails, your chat, and your SharePoint, augment articles and any other relevant external information for you so that you can quickly get up to speed with what's happening. This is great if there are pieces of legislation or case law that you need to understand, or if there have been developments across any subject matter within your specific legal field that you need to have visibility on. You can use it to prepare prepare comprehensive analysis, including the regulation provisions. You can collaborate with your stakeholders in Teams as well. In Teams, you can create loops, you can create notes where everyone can collectively participate and add their input. You can create internal guidelines, and this again goes back to the no or the low code. You can use it in Copilot Studio as well. You can do risk assessments and you can create external communications as well. All of these can form one or separate workflows. We can move to the next one. When you're doing licensing agreement negotiations, we found if we're leveraging it when we're negotiating contracts or even when we are trying to do pre-trial work, it reduces the negotiation period, but also the consultation period, because using Copilot can help you identify gaps. Our position compared to the opposing counsel's position or the opposite counsel's position, we can use Copilot to pull up what the differences are, where there are gaps, and help us find what the common ground is, resulting in a win-win, but a quicker turnaround as well. It speaks to being able to give real-time support, reduction in the revenue costs, but also enhancing the experience for parties on either side. We can move to the next one. While I can't do the videos, I can just show you if you had to take any piece of case law. So this is a judgment of Kunal Kamra, and you have saved it to your OneDrive and you now open it within Word. You, on the side, open your Copilot chat window, and I've just put down 4 simple prompts that you can ask Copilot to help you surmise the judgment, but also help you understand what specific clauses are within the High Court ruling. Another example is what grounds have the respondents relied on to establish the validity of the rules, and then why was the decision referred to third judgment. What happens is Copilot gives you the outputs with a citation or a reference, and it takes you directly to that clause and to the reference that it has used to get to the output. We can move to the next one. Similarly, here you can see it actually gives you the answer. If you're asking it, give me a detailed and crisp summary of the case in bullet points. It was a 1 prompt, not a complicated prompt given to Copilot based on this Intex versus Ericsson judgment. And it did exactly that. It went and it gave the bullet point detailed summary of the case with the citations. You'd see there 1 and 2. If you click those, it goes and it takes you directly to those within the document. You can then continue the conversation further and ask what concepts what is the concept of standard essential patent. If there's anything that you don't understand in the judgment, ask it. Copilot is going to help you get to the crux of it. It's going to help you explain it. You can also use it within a web setting, and you can toggle it to that to help give you more information and a better understanding if you don't have that context, so you can't get to that understanding within your own OneDrive environment or your work environment. If we can move to the next one. It also helps you seamlessly draft contracts. You don't have to have a template of the contract. You don't have to have your policies necessarily loaded. It does help. Like I said, it does connect to, it is able to add on to connectors. It is able to refer to your policies. What you can do is just give it a simple prompt, tell it what you're trying to do. This is a purchase agreement between one seller and one buyer, transferring entire shareholding from the company of the buyer. And then it also has conditions set out what you're trying to achieve with the share purchase agreement. And within that one prompt, Copilot went and it generated a basic but still thorough share purchase agreement based on the prompt and the details that you've given it. What you can then do is go in and you can further ask Copilot and prompt Copilot to help you further refine the agreement. You can load your policies or your templates in as examples, and it can then further refine it, align to your templates. If there are certain clauses that you'd like for it to include, what you can do is not redline. It can't redline it for you, but it can reference existing clauses and draft in line with those existing clauses for you, ensuring that you are complying with either best practice or your in-house standard policies. So similarly, I had that question now, I just want to answer the one before I jump. How do you utilize Copilot to give you the summary? What you do is open up the PDF that you've saved, and you can then open Copilot in the window next door and on the same PDF document and ask it to then provide you with a comprehensive summary. You can even give it pointed questions. Can you tell me what this clause says? Can you tell me what this agreement or this document says about X, Y, and Z? Can you help with executive summaries, etc.? I am able to demonstrate if we have time. I know everyone has allotted some time to do their presentations, but if there's time at the end and there is the ability, I can go in and I can demonstrate. So I think I'd hand it over to Catherine, and then I'd take guidance in the Teams chat on, sorry, in the chat window just on the questions.
Thank you very much. Good afternoon, good evening, good morning, everyone, from wherever you're listening to or you're watching us from. And thank you very much to everybody who's joined today's session. Thank you, Bhumika and Andrea, for placing that foundation for us for today's conversation. And we've just had a rich international perspective on AI innovation and the broader, what we call the broader global shifts shaping intellectual property framework. And I think that's what Bhumika and Andrea have done for us. So allow me to take a slightly different direction and now bring that conversation closer to home in East Africa. since we are lawyers around in East Africa who are attending this session. So what I'll try and do for the next 20 minutes or so, I'll try and paint a picture of a more granular, I'll try and paint a more granular picture of what's happening here in Kenya, and I'll also cover Tanzania. And then my colleague David will come in a bit later and cover Uganda and Rwanda. What I'll cover for the next 20 minutes is really how our legal frameworks here are structured and how, say, IP disputes are being resolved in practice, and what are the emerging issues that we're seeing in these markets that reflect and sometimes even anticipate the global shifts. So just to clarify, we are definitely, on this East African side, we are definitely not exempt from global trends, and the same questions around, AI, deepfakes, data ownership, digital enforcement are really playing out right here, just like they are globally. So then, rather than repeat what has been covered before, what I'll focus on is the local framework and how our laws and institutions are responding, as I mentioned. So we'll start with what's unique in each country, that's Kenya, and then I go to Tanzania, and then I'll cover the shared regional picture, including, arbitration, emerging tech, like I mentioned, like the deepfakes, which have been covered before, and why, then we look at the EAC framework, and why we still, maybe question why we still lack a common IP framework as East Africa community. So then when we come to Kenya, I'll quickly gloss over the basics and how our framework looks like. So the main statutes in Kenya are, we have the Copyright Act, we have the Trademarks Act, we have the Industrial Property Act, and then we have the Anti-Counterfeit Act. All these acts have regulators that enforce them. So you'll find we have the Kenya Industrial Property Act, or KIPI as we call it in Kenya, which covers patents, industrial designs, trademarks. And then we have KECOBO, which is the Kenya Copyright Board. And this usually now covers the copyright and collective management and such issues. Then we have Kenya, which covers innovation and tech transfer issues. And then we have the Anti-Counterfeit Authority, or in Kenya, as we call it, the ACA, which covers the counterfeit enforcement issues. When it comes to disputes around IP, in Kenya, they are handled mostly by the Industrial Property Tribunal under the Kenya Industrial Property Institute, and it hears appeals and compulsory license matters. So most infringement, trademark and copyright suits then go directly. You'll find that most infringement, trademark and copyright suits will go directly to the High Court, while there are some matters that are reserved for the tribunal. And in the High Court, we don't have specialized courts in Kenya when it comes to IP. So most of our IP matters go to the commercial division of the High Court. I know some of the things that we've been pushing for is, like, for example, we have a specialized labor court in Kenya, and we've been pushing for having also a specialized IP court to just increase the skill set or at the judiciary level. To understand how Kenya's IP framework operates in practice, it's helpful to look briefly at two cases that have affected the market in the last few years, and they capture both sides of the conversation. That's the creative industry and the digital economy. And really, what these cases have done in the Kenyan market is they've showed us how courts are interpreting IP rights in a changing environment. As I mentioned, our framework, the laws that we've had them for a long time. So sometimes, and they haven't been reviewed really to reflect the emerging issues in the market. So we've had to look at courts and how courts are interpreting IP rights in a changing environment for us to know the positions held. One of the cases that we look at, it showed us how far responsibility goes when you're verifying ownership before using digital content in this day and age, especially in the social media day and age, and how online platforms and social media are becoming, the new arenas for trademark enforcement. So the first case is called Kimani versus Safaricom. Safaricom is a Kenyan, one of the leading Kenyan MNOs. And this involved a popular artist in Kenya called Bamboo, who sued Safaricom, claiming that his songs were sold on a certain platform called Skiza platform without his authorization. So Safaricom, in their defense, came in and said that, you know, they had paid content aggregators, and therefore, because they had settled with the content aggregators, then this artist Bamboo was supposed to go after the content aggregators and not necessarily Safaricom. But then the court disagreed in this case and awarded damages to Bamboo, and Safaricom was required to pay Bamboo Kenya shillings 4.5 million in damages. And what the court held in this case is that digital distributors must contribute to due diligence to confirm ownership before commercializing music. So Safaricom should have established that indeed they were paying Bamboo, and that the aggregator indeed had gotten rights from Bamboo in order for Safaricom to pay them directly. So this was a turning point in the Kenyan scenario, where we have very many aggregators when it comes to the creative scene, and it signaled that platforms really can't hide behind intermediaries. And for those who know the Kenyan market, there's a lot of intermediaries when it comes to the creatives industry. And what it said is that these platforms have direct responsibility to verify rights before monetizing creative content. The other one that I'd like to highlight, which has also been significant in the market, we had a matter for Catherine Matitsa and another versus Samantha Ireri. So this case, why it's important is it involved an Instagram account that was called Color by Samantha. So what one party alleged is that the look and feel of the Instagram account was confusingly similar with their account, and therefore the trademark was confusing the public with the plaintiff's Samantha trademark. What the court in this case did, it dismissed the claim for, you know, lack of a prima facie case. It noted the social media activity, that social media activity can actually constitute trademark use, and that acknowledgement was significant for our market because it marked the digital turn in Kenyan IP enforcement. That said, I'd like to highlight the emerging issues that we're seeing in Kenya, and also Tanzania, that largely reflects the global shifts, as I mentioned, and especially around AI, deepfakes, digital enforcement. That's just like it had been covered before. As I said, a lot of what is happening in Kenya and Tanzania reflects also what is going on, you know, worldwide and the global trends. So it shows that our region is also grappling with the same challenges shaping IP law worldwide. For instance, when it comes to AI and deepfakes, on the AI front, Kenya launched its AI strategy in for 2025 to 2030, and also this year there was a lot of policy work around AI. We don't have a dedicated AI law, but then there's a lot of policy work around AI, and you know, the lack of a specific AI Act, I guess, you know, becomes evident when it comes to, you know, how to address these deepfakes, synthetic images or voices of real people being used without consent. I think this year and last year we had a lot of activity in Kenya where with the president, images of the president being used, deepfake images being used. And I think most of the action that we saw was on the criminal side of things. We have the Computer Misuse and Cybercrimes Act, so it was addressed from the criminal aspect of things. But we're still waiting to see our law catch up and maybe have a dedicated AI Act to deal with some of these issues. Our Copyright Act definitely, as I said, is very what I'd call old school. You know, it was drafted, for example, for human authors and, you know, did not anticipate AI authors, doesn't fully cover machine generated works or AI manipulation. So, I mean, enforcement still remains reactive, but there's a lot of activity in terms of trying to address policy and also call for reforms in most of these laws. The other thing that we've seen a lot of activities when it comes to anti-counterfeit issues. And in both markets, we've seen a lot of like anti-counterfeit activity. So in Kenya, we had the anti-counterfeit recordation regulations that were enacted in 2020. And this required importers to record all trademarks tied to imported goods, enabling custom officers to stop counterfeit goods at the border. This was a big step at the time. And it really helps it really helped parties when it came to brand enforcement in the market, since there was a lot of anti-counterfeit activity in the market, and the players, the real owners, were finding it hard and not finding a framework that supported their brand enforcement initiatives. When we cross over to Tanzania and we look at their legal and institutional framework, I have to mention that the East African countries largely mirror each other. The moment there is a change in law in one country, most likely you are going to see the same level of activity and changes in law in the other activities. So we tend to really mirror each other even in the laws that we have. So across in Tanzania, the IP regime, I'd say, rests on the Trade and Services Markets Act, the Patent Registration Act, and the Merchandise Marks Act. Their oversight relies with BRELA. BRELA is the one that handles, registration of patents, trademarks, designs. Well, in Kenya, I mentioned it's KIPI. And then there is COSOTA. COSOTA handles the copyrights. While in Kenya, it's TEKOBO. And then both Kenya and Tanzania are also part of, the regional institutions like, WIPO, ARIPO, and that's something to do. Although Kenya, while a signatory of ARIPO, has not yet enacted it, and therefore, while Uganda, Tanzania, and Rwanda have. When it comes to landmark cases that maybe we'd like to highlight from Tanzania, they've also had their share of good landmark cases that have informed jurisprudence when it comes to this area. So, for instance, there was a case in 2022 where between China Friendship Textile Company and Nida Textile Mills. So in this case, the plaintiff accused the defendants of copying Panga and Vitenge fabric designs, which, as we know, Tanzania has a huge market for these Kanga and Vitenge fabric designs. So what COSOTA, once COSOTA certificates confirmed ownership, then the court ruled that the plaintiff, for the plaintiff, and awarded damages to the plaintiff. So what this case firmly established was judicial protection for artistic works in the textile industry, which is a vital precedent for Tanzania creatives. As I mentioned, that's a huge market for them. When it comes to AI and anti-counterfeit, Tanzania has completed a UNESCO AI readiness assessment and is developing a national AI strategy aligned with AU Continental AI strategy. They also don't have a dedicated AI Act, but as we can see, there's a lot of policy activity around AI as well, just like in Kenya. And then they also have the merchandise marks recordation regulations 2025, which now require recordation of all trademarks on imported goods, mirroring Kenya's system that was there in 2020, that was enacted in 2020. Let me mention a bit about what activity I've seen and how I've seen what you'd have called boilerplate clauses that we used to put in contracts. So as a commercial lawyer practitioner myself, I've seen how over time we've moved from looking at, that IP clause just as any other boilerplate clause. Now we pay closer attention to the clause, depending also on the type of contract or agreement that you're doing. And now we pay so much more attention on IP-related contracts or IP-related clauses as well. So we are increasingly embedding arbitration clauses in IP-related contracts, which wasn't common before. So for instance, in licensing, franchising, tech transfer, software development, NDAs, and even database ownership agreements. We're looking at this because of the benefits that contractual arbitration would offer as opposed to, let's say, going to courts. And there's a confidentiality, of course, that sometimes the parties prefer. There's a speed, there's the expertise, because remember I said, like, courts, we don't have specialized IP courts. So, but in this case, you can get a specialized arbitrator, and the parties can appoint an arbitrator who understands IP or tech, very specialized. There's also the, cross-border enforceability that we looked at. Can the award be recognized in other countries? And then we also usually look at the element of, we want to preserve the business relationship. It's if you think about it, arbitration is a bit less adversarial than, say, going to court, and probably useful where business partnerships will continue afterwards. Especially in the fintech sector, we have a lot of business partnerships. So we're finding commercial lawyers prefer to building a lot of ADR clauses into the IP clause as well. But that said, it's good to mention that in the IP space, there is always certain issues that remain reserved for regulators and courts, like the regulators I had mentioned in both Kenya and Tanzania. So, issues to do with patent or trademark registration, opposition, validity, you'll find that those will be handled by KIPI in Kenya and BRELA in Tanzania. Copyright issues, or, you'll find that some copyright issues that will be handled exclusively by Kekobo in Kenya or KOSOTA in Tanzania. Then you will find, some issues like, passing off issue. It's a dispute including passing off, where one party is accusing the other party of passing off, another maybe statutory infringement actions. You'll find that those will be reserved to be heard in the High Court. So then what you find is we IP practitioners, we really move around a lot between, you have a matter before the regulator. Tomorrow you'll have a matter before the High Court. The other day you will have, a matter before Kekobo. So it's really dependent on what matter it is. The other time you will be representing a client before an arbitrator, because it's a matter that qualifies for arbitration and the parties opted to go for arbitration. So you can find yourself going and you have to build your skill to appear before all these parties when it comes to IP dispute resolution. So then maybe what I'll also mention, given that there are those different scenarios, it's always important when you're building your IP clauses in the agreement to include what we call the carve-out clauses. The carve-out clauses is where you will reserve a certain matter, which, for instance, can't go before arbitration. Then you reserve it for that particular registrar or authority, and you will say something like, any dispute arising from this agreement will be resolved by arbitration, except maybe matters requiring determination by the relevant registrar or authority. So that said, what I'd like to emphasize for the IP lawyer in East Africa is that the IP clause is no longer a boilerplate provision, as I said, and you have to really think about it and have it as a strategic clause that will, promote your client's interests and rights, as well as, in case it's business, promote your client's business, should be strategic. So when it comes to alternative dispute resolution, the Kenyan picture, we have the Arbitration Act, we have the institution as well, the Nairobi Center for International Arbitration. So we have a robust framework, and that's what the parties usually rely on. Because like NCIA rules in Kenya even allow for what we call the emergency arbitrators, which is perfect for IP issues like, preventing the launch of an infringing product or app, or halting authorized use of proprietary data. So those are the things that we really consider. And in practice, you'll find arbitration is very common in, say, fintech and software ownership disputes, white label platform licensing, API integration and revenue sharing conflicts, and data use and confidentiality breaches. Then you'll find, as I mentioned, most passing off and infringement cases will go before the High Court, and then the other cases will go before the regulators. Although especially in Kenya, the courts themselves actively promote mediation and ADR. So once the parties express their interest to go to alternative dispute resolutions, the court easily adopts that. From a regional context, because we are still members of East Africa community, the one thing, I know there is the EAC regional IP policy, then we have the EAC TRIPS flexibilities policy. So they've tried from a policy angle to try and harmonize laws and, promote innovation. But what we still lack in East Africa community is a common, say, IP registration and enforcement framework. So for instance, like at Cavendish in Kenya, we always, if we want to register, a client wants to register a trademark in Kenya, Uganda, Tanzania, or say Rwanda, we have to do them in those jurisdictions individually, because there is no single East African trademark or patent or copyright office. So one of the things that we've been pushing for as players in this space is to have that single East African, trademark, patent, or copyright office, because it will make it so much easier. Because currently, I register my trademark in Kenya, it doesn't automatically protect you in Tanzania. So we are hoping that that framework will see those changes over time. Then for both countries, as I mentioned, there are no specialized IP courts. So we are hoping that we'll see those changes. There's also the element of laws lagging behind emerging tech. But to be honest, I think that's a global issue that's not unique to East Africa, but there's always the hope that, the law can try as much as possible to catch up with emerging tech and any disruptions. Then there's always enforcement gaps that both jurisdictions grapple with, where online infringement will probably spread faster than a regulatory response. I think we've seen that a lot in Kenya, especially with deepfake technology being used, where we've seen, for instance, deepfake tech being used to blur lines between creativity and manipulation. But as I said, in Kenya, the Computer Misuse and Cybercrimes Act, which criminalizes most of these things, tries to bridge the gap beyond civil enforcement to handle, say, some IP violations such as counterfeiting, piracy, and some criminal offenses. So there's that criminal aspect as well that some people forget to think about, that as much as it's a civil and commercial element of side of it, there's a criminal enforcement of IP, mostly in the counterfeits and the piracy side. And they really complement the IP laws in a large way. Then I'd say both jurisdictions are evolving in the same direction, both Kenya and Tanzania, because Tanzania also has their Cybercrimes Act 2015, while ours is the Computer Misuse and Cybercrimes Act 2018. What I'd close and say, as I invite my colleague David to come in, is that all of us as council innovators and in our own way, and also as supporting innovators in the digital space, we need to keep pace also with the emerging laws and the court cases, keep a pulse on the court matters and what's happening in the courts and how courts are interpreting some of these, some of the emerging issues in the emerging IP issues in the digital space. And definitely, even as we support our clients, for businesses, well-crafted IP clauses with clear, say, dispute resolution paths and carve-outs. I mean, they're now, if you think about it, risk management tools and not just formalities. And obviously, even as a market for investors, strong IP rights signal a secure environment for innovation. So then, in conclusion, IP today is not just about ownership. It's really about how we help our clients commercialize and protect the innovation across jurisdictions, and do so efficiently, confidently, and with foresight. And with that said, I'd like to invite David to give us the perspective of Rwanda and Uganda as we conclude, and I'm looking forward to the Q&A session. Thank you very much. Over to you, David.
Thanks a lot, Catherine. That was very comprehensive. Thank you very much. I can say I've also learned a lot from Kenya and Tanzania. I'm going to request that I keep my video off for purposes of keeping the network on while the slides, I think my network is just a bit shaky. So please allow me keep my video off. So for Uganda and Rwanda, it's a very interesting where Catherine has also ended, especially with that comment regarding it's no longer about ownership and fighting for infringement, but also guiding our clients on strategizing commercially. Because I understand that many of them, as much as they have these intellectual property rights, they are not necessarily planning on how to use them, on how to exploit them, on how to enforce their rights if they're registered. And so I think these are all areas that we'll look at. Specifically for Uganda and Rwanda, what I would like to focus on is alternative dispute resolution. So all the speakers who have come before me have spoken about the normal dispute resolutions. Catherine has highlighted a lot about arbitration, but I'm going to focus specifically on ADR because I feel like this is a growing opportunity for many of us as lawyers, and also considering that the normal methods of dispute resolution have also fallen short in many ways, especially when you consider expertise in intellectual property. So many of the judges you will find are not very much conversant with these laws and how the nuances in intellectual property apply to real life situations. Many of the methods that are provided for by the law, like appeals, as mentioned even by Catherine, appeals that are sent to the registrar themselves sometimes yield no resolutions. So we find ourselves in a position to consider other dispute resolution systems. We can move to the next slide. So I want to, first of all, just talk about generally, do the laws in Uganda or Rwanda, specifically the intellectual property rights laws, do they provide for alternative dispute resolution in any way? Do the alternative dispute resolution laws consider intellectual property in any way? So this was the focus of my research for this presentation, and starting with, for instance, intellectual property law of Rwanda, which has just been amended in 2024. As much as it is modern, comprehensive, provides for things like digital copyright, which are not seen in the Copyright and Neighboring Rights Act of Uganda, still there is completely no mention of alternative dispute resolution. I think, of course, this will, when you compare this to Uganda, if you move to the next slide, different from Uganda, of course, we understand that Rwanda has only one general intellectual property rights law. It governs all intellectual property, so including industrial property, including copyright, including trademarks, are all in one law. And it's within that law that I thought it might be easy to at least promote, let me use the word promote, alternative dispute resolution, but unfortunately there is no mention in the Rwandan law. When it comes to the Ugandan law, there's a bit of a mixed bag, if I may call it. Specifically, if you look at the Copyright and Neighboring Rights Act, you'll find that ADR is mentioned. Arbitration is actually promoted therein, like Section 78, but this only applies to collective management organizations. I believe that the collective management organization in Uganda's case, the most popular one was the Uganda Performing Rights Society. Well, unfortunately, because of the many issues involved there, we know how artists have been, members of that organization have been coming up and saying that they're not getting enough money. Many of the popular artists like Kenzo have come out and said they're receiving only about 6,000 Ugandan shillings, and compare that to how they believe they're booming on the international scene doesn't make sense on the local scene. And I think these are interesting areas to explore. But of course, if you explore these in the normal court procedure, we will know that there is a lot of backlog, there's a lot of time that will be consumed, and yet the law itself provides for the possibility of using arbitration to resolve disputes among members of collective management organizations like UPRS, that is the Uganda Performing Rights Society. Under the Industrial Properties Act, you'll find that arbitration is mentioned specifically for technovation. So if you know technovations, and the most common, of course, way of defining it is if you're an employee and you figure out a new innovative technological way of achieving a particular task, especially even though it is part of your duties, you are capable of getting a technovation. This is also a type of intellectual property right. If you look at the Industrial Properties Act, it provides for arbitration in disputes related to technovations. However, still there is limited people who have applied for that right. And if you talk about the disputes, they're almost they're almost none completely. None of them have reached the point of even deciding to have the matter heard in court, let alone finding an arbitration system to go for. And I think I should also mention at this point that disputes relating to intellectual property in Uganda and Rwanda are still very limited. We have a number of examples in trademarks, which is true, because from opposition to registration, you'll find that people are always opposing or trying to remove other entities' trademarks for infringement, for similarity, maybe for passing, or for free riding, or for counterfeiting, and these are the most common of them. But even considering the presenters who came before me, you realize that copyright is about to get more traction than it has ever gotten, especially with the coming of artificial intelligence, especially with the rise in deep fakes, in people using AI slopes where they can infringe on other people's work without even knowing that they're doing so, I think is where we're heading to. Different innovations that we're using AI to create are going to come under the Industrial Properties Act, and that will include patents, it will include utility models and industrial designs. I believe that of course room for growth as far as the dispute resolution is going to grow while the disputes themselves grow. Because right now I can say that the main matters that even from the examples that we are hearing, unless they are involving some sort of new tech advancement, you realize that it's mainly about trademarks and brands. If you look at the Trademarks Act of Uganda as well, there is no mention of alternative dispute resolution. And maybe it's difficult to also talk about an alternative dispute resolution when it comes to trademarks, because trademarks are the resolution of disputes in trademarks is dictated strictly by the law, starting from the period of publication when oppositions can be filed. You'll find that there's strict rules on how trademark disputes are handled, and that doesn't leave any room for promoting alternative dispute resolution. However, I believe that doesn't mean that it's impossible. It just means that we should talk about it more and find a way of including it. Please move to the next slide. So the ADR landscape, I'll start with the one in Rwanda. Of course, in Rwanda, we know it as being stable because the Kigali International Arbitration Center, commonly known as KIAC, has been around for a very long time, since 2010. It is the only body in charge of, the main body in charge of handling arbitration in Rwanda. It also trains professionals in becoming arbitrators, and you can look at their website for the different resources. And if you're interested in taking part, of course, you can look at their website. One of the main key advantages that KIAC enjoys is strong judicial backing. Also, you'll see there that in 2022, it was reported that there was no KISE arbitral award that had been set aside by the Rwandan courts. And this, I think, provides a lot of confidence in the market for foreign investors and others to just know that besides the court system, even in intellectual property matters, I can run to an arbitration center such as KIAC. We can move to the next slide. Now, for the one in Uganda, for the situation, for the landscape in Uganda, as some of you may know, previously there was a Center for Arbitration and Dispute Resolution, but it was abolished with the amendment of 2024, and its functions were, should I say, sent back to the Ministry of Justice. So similar to many government offices last year that were in Uganda that were returned to the ministries, the same happened to the Center for Arbitration and Dispute Resolution. So it's now a simple desk in the Ministry of Justice, and I think it will be interesting to see in the future what particular role they will play. However, that doesn't leave the landscape bare, because there is the new independent International Center for Arbitration and Mediation in Kampala. And I think this plays also a vital role in providing another platform for resolving intellectual property disputes. I know many people find that it's an argument regarding the brand. Is it your brand? Is it mine? Are you copying? Many people feel that these are types of disputes that are well suited for courts, but again, because of the issue of capacity and experts, the aspects of intellectual property, especially matters being handled on their merits, is not sufficient due to that lack in capacity. While in arbitration matters, we all know that the arbitrator, whoever is chosen, can appoint experts to sit along with them and help them resolve some of these matters. And I believe that these are areas that lawyers should as well look into as opportunities for them in the future, considering all these problems that are coming intellectual property-wise. We can move to the next slide. So we can now look at the pathways for local insight. Also, if you are interested in filing your matter or handling your dispute, your intellectual property dispute under alternative dispute resolution, now you realize that there's going to be a strict focus on how you draft your IP clause, for instance. We, as Catherine has mentioned, the boilerplate clause is no longer applicable. Now it's important that you think about, for instance, what happens to intellectual property before we enter into this transaction. The intellectual property we create on our own before we enter into a partnership, for instance. Then while we're in the partnership, what happens to the intellectual property created there? And then also, most importantly, in case any dispute arises regarding intellectual property, can we say maybe save that for arbitration? And I think these are all ideas that we can come up with, depending on, of course, the particular context. It's always, in my opinion, it's always advisable that you consider alternative dispute resolution, because intellectual property disputes can become very complex. It's not just about trademarks and brands. It can be about now technological advancements. Important questions were asked by the presenters who came before me, such as if artificial intelligence creates, can we say that it can own copyright? Some of these questions are not going to be properly answered in our normal dispute resolution platforms. And I'm suggesting here that you can choose voluntary arbitration, for instance, which can be expert-led, the ICAMEC rules, accept that. Previously, which I know now is not the same situation, there was a mandatory mediation which was led generally by court. It was annexed to court, whereby all civil matters had to commence by mediation before going to court. And if you went to court before mediation, I understand that this could be challenged and sent back to mediation first. However, this was not very helpful when it came to intellectual property matters. Like we've mentioned, copyright disputes are about to become more complex than we've ever seen before. And we well know that most of the court backlog and why most of the disputes are not handled to a satisfactory to their satisfactory end is because of the lack of capacity, not just with the people, in other words, the judges, but also even involvement of experts in testifying, in evidence and more. We can move on. So the question is, are we ready for these complex IP disputes? And in my opinion, we are. We are because the institutions are available. Like we've mentioned, regardless of the issues involved. In Uganda, ICAMEC rules are very applicable, and as lawyers, we have the opportunity to involve ourselves as arbitrators, to involve ourselves as experts, and also just advocate for the use of ADR in IP matters. For CLIAG, they have clear authority to appoint one or more experts as well in their rules and in matters of intellectual property disputes. Again, many of the lawyers should look at this as an opportunity to grow their careers in arbitration, grow their careers in intellectual property. So if you consider all this, then you understand that if the institutions are available and are ready, then if we involve ourselves as the lawyers, we can also help make this complexity not that complex anymore. Yeah. We can move to the next slide. So as I've been mentioning, IP arbitration in practice, this is an untapped opportunity. So the infrastructure is there, but the question is, are we using the infrastructure? And despite the fact that we are ready, there are no significant or landmark reported cases of IP disputes being resolved by arbitration in either jurisdiction. And of course, maybe depending on which jurisdiction you're coming from, you can offer different examples, but from my research, it clearly shows that there are no matters being, and of course, like we've been mentioning, arbitration is commenced by an arbitration clause, and meaning this starts from the contract itself. If the contract is not properly drafted as far as IP is concerned, looking forward to maybe situations of IP disputes and reserving IP disputes specifically, or the contract in general, of course, for alternative dispute resolution like arbitration, I think that's still lacking. I think we need to consider all this at the point of drafting contracts and not just at the point when clients come and mention that their rights have been infringed. This will save us a lot of time, costs, and also it will help us resolve these matters on their merits, as opposed to just being thrown out of court for technical issues like failure to use the proper method, like failure to come up with your cause of action in a proper way, and similar preliminary objections that could affect your intellectual property dispute. So down there, I say that this is the biggest growth for the bar, especially for the different bars. I think we need to look into how we can discuss involving ourselves. I also wanted to just mention that if we are to talk about the involvement of technology in handling these disputes, both institutions that I'm mentioning, both from Rwanda and from Uganda, are completely ready, because the ICAMEC rules provide for online arbitration, and recently the Kigali International Arbitration Center also launched its e-case management system in April 2025, and I think this is a big step forward, especially for the region. I understand that of course, we have different takes on how our court systems handle IP disputes, but when it comes to arbitration, we have that freedom of contracts to choose the place of arbitration, to choose the seat of arbitration, and regardless of whether you are in Uganda or in Rwanda, you can still file your matter with the Kigali International Arbitration Center, simply because of the trust that they have built over time and the court backing that they have, as well as government backing. Yeah, so we can move on to the next slide. So what are the tech challenges? The tech challenges, as we know, are very common, especially when it comes to how we adopt technology. Us as the lawyers, as much as Uganda, for instance, has released its audio-visual court link rules, as much as Rwanda has also promoted the use of the e-filing systems, are we ready to use them? Do we have to be tech savvy, for instance, to be able to use them? I believe, of course, that we must as well consider other fears that come with technology, such as data protection, infringements, privacy, confidentiality, and all these other things. But just thinking about it, are we ready as lawyers to advise a client that, oh no, you can file your matter in Kigali International Arbitration Center. We won't have to necessarily go there. We can handle the matter online. This is much cheaper than having to go and enforce your brand rights or your trademark rights, for instance, in a completely different jurisdiction. For instance, if you found out that your brand is being registered in Rwanda, but you're not registered in Rwanda, and you want to go and have a dispute, of course, you can't skip the stage of opposition, but what if you've missed that stage of opposition? Can the law provide for an opportunity to maybe arbitrate some of these things? I understand that the law is strict on how we should handle trademark disputes, but what about when it comes to copyright? What about when it comes to the relationship between collective management organizations and their members? What about those disputes? Is that something that we can handle online? Is that something that we can prepare ourselves to handle in arbitration online? So I believe also in the interest of time, we can move on. So the main, of course, the main approach that I'm suggesting there on that previous slide is the ability to do a hybrid system whereby you can have parts of the dispute settlement online. You can also have some of them physical. I understand this is important because at times some witnesses, some experts may be hard to reach, but if you do the hybrid system, this can be a good solution for the hard to reach areas, hard to reach experts that you may need to help you resolve an intellectual property dispute. So this is just a snapshot of a comparison. It's not that much different if you really consider the outcomes. Maybe just that on the side of Uganda, they have now concentrated on ICAMEC as opposed to SEDA, which was abolished. And as much as in Uganda, they mention arbitration in some provisions of the laws relating to intellectual property. In Rwanda, there is no mention at all. In both, of course, Uganda and Rwanda, you can stay proceedings in case there is an arbitration clause within within an agreement, and of course, arbitration will be considered first before you actually approach the court. For tech readiness, I'm considering both of them as high and ready to have as much as hard. We can move to the next slide. Opportunities for growth. We must, of course, consider where we stand, and Catherine also mentioned this. It would be interesting to have a regional office, for instance, East African community being able to apply in one place and then apply in Uganda and cover Kenya and cover Tanzania and cover Rwanda. Aripo, of course, is trying to do this, and with Aripo, you can cover a number of countries and you can align, of course, with them. When it comes to the AFCFTA, they have also talked about the ability of applying in one country to cover all African countries. This would be very advantageous because it would streamline the ability of people to protect their intellectual property rights over the entire region, but also it will make it easier for us to create one consolidated maybe platform where we can have rules on on use of alternative dispute resolution in intellectual property disputes. The AFCFTA dispute resolution protocol provides a good mechanism to push cross-border recognition and enforcement of IP arbitral awards, whether they are rendered in Kigali, whether they are rendered in Kampala. I think this, moving forward, these are all opportunities that we can look to. Yeah, it makes the system stronger, more predictable, and more attractive, of course, to the investment climate of the entire region. We can move on. So, of course, the takeaways that we are going to have to take today is, for Rwanda, we can consider, of course, when the next time comes for amendment, which of course will be announced, it's easy to take part in here for experts and advise that we should encourage voluntary mediation and arbitration within the law itself, because the law is completely silent on the possibility of this, and you find that most IP clauses are being drafted based on the law. And if the law is not advising in one end, I think, of course, even the lawyers who are drafting will not remember to consider ADR. For Uganda, again, we should consider broadening the limited mention of ADR in the various intellectual property laws. And then we should also find ways, of course, as East Africa Law Society, as ISLP, and all the different bar associations, we should as well look into how we can sit down with KIAC and ICAMEC, for instance, and talk about developing supplementary rules that are specifically in relation to ADR or arbitration in intellectual property disputes. How that looks like, of course, we have many resources to look at, including the WIPO, the World Intellectual Property Organization rules, alternative dispute resolution rules that can as well guide us. I believe that's the end. Please move on. Yeah, so thank you very much for listening.
Thank you very much to our panelists and to everyone who joined us for this engaging conversation on navigating legal disputes in the digital age and international best practices in intellectual property rights. I'll take the next few minutes to summarize some of the key takeaways from our today's discussion. We began by exploring the fundamental debates around AI and copyrights, from the questions of who owns AI-generated content to whether such works can truly be considered original, and how principles like fair use apply to training data for large language models. We also saw how different countries are developing their own legal frameworks to balance innovation with creator protection. We then turned to the concept of responsible AI, emphasizing that technology should serve as enabler, not a replacement of human creativity, ethics, and judgment. We saw practical illustrations of how tools like Microsoft 365 Copilot can support legal professionals in research, drafting, negotiations, case analysis, allowing us to work smarter and faster with upholding professional standards. From a regional perspective, we compared Kenya, Tanzania, Uganda, and Rwanda's approaches to IP dispute resolution. In Rwanda, we saw a strong and stable model. In Uganda, the arbitration landscape is still in transition. And both in Kenya and Tanzania, we've seen the launching of recordation of intellectual property rights to fight counterfeits. Generally, EAC countries have the legal and institutional framework to handle complex IP disputes, including ability to appoint technical experts. And the infrastructure is ready and the legal community has been utilizing the current frameworks. However, one of our panelists believes that the real opportunity lies in actual utilization of the current framework, and there's a need to set more precedents in IP disputes. We also acknowledge the impact of technology and virtual hearings on dispute resolution. In all countries, Kenya, Tanzania, Rwanda, and Uganda, we see embracing of digital tools, though challenges such as internet reliability My sincere apologies. Technical difficulties happened again, embracing tech. So I'm not sure where I was thrown out of the meeting, but I'll try to wrap up my comments. So outside the East African community, we have the opportunity to leverage regional frameworks under the ARIPO and the AFTA to harmonize IP arbitration standards and also promote cross-border enforcement of arbitral awards. Upon reflection, it's clear that AI is not a threat to legal profession, but rather a tool that can expand our capacity for insight, innovation, and impact. So what will be ideal for our next steps? I believe we can combine sound laws, modern tools, and skilled practitioners. Africa can position itself as a leader in the digital age dispute resolution. For the next few minutes, we will take a few questions. In no particular order, I will direct our questions to our panelists. Our panelists, if you can please put your videos on, if you can, we will appreciate that. So our first question goes to Bhumika. Feel free to highlight any personal comments, and where you cannot, we are happy to hear from the rest. So do you share the data you receive with the government or other security agencies? Bhumika, any comment on that?
So I'm not really sure if this question was directed at me, or will Andrea be the better responder to this question, because I think Andrea was showcasing a lot of Copilot demonstrations.
Okay, Andrea? Andrea, are you able to hear us? As Andrea is preparing to come up for the first question, Bhumika, will you respond to the next question? When you edit content drafted using AI, should you cite to avoid plagiarism?
Right. So I think there are multiple aspects to this question. Obviously, there are both legal and ethical considerations when you're using AI to prepare content or produce content. Like I can tell you from a legal perspective, a lot of the jurisdictions already have laws which require transparency in content that's being produced from AI. For example, the EU AI Act requires transparency wherever AI is used. Similarly, in India also, there are laws which are coming in where watermarking of AI produced content is now going to become mandatory. Legally speaking, I think the way trends are evolving is that transparency on AI content should be included. And ethically also, I think when you're using AI to create something, best to obviously be upfront about it. The context matters a lot. I mean, what are you using the AI content for? If it's only for your personal reference, probably it doesn't really matter if you are being transparent about it, or if you are reworking on the content that AI produced in a way where it becomes your own product thereafter. Again, then it doesn't really matter whether AI helped you ideate, because essentially there's human intervention which has gone thereafter. So I think context matters a lot. The kind of AI systems you are using, how reliable the AI systems are when it comes to trusted data being produced. All of these matter a lot, but legally, ethically speaking, I think best to be transparent about usage of AI.
Thank you, Bhumika. Moving on to the next question, which I will direct to David. How should someone approach legal compliance on the part of an app developer who relies on AI agent from sources such as OpenAI to run the app? Kindly, what intellectual property rights should they acquire from OpenAI? David, if you can share a comment on that.
Right. Thank you. That's a very good question. Also, as it was mentioned before, especially in the region, currently we do not have specific laws that govern artificial intelligence. And right now we are left in that confusion, understanding, okay, so between me and OpenAI, for instance, who would own the intellectual property right? Because that's where I believe that you should even start from before you think about asking them for that right. Which particular right are you talking about? How much have they contributed to the development of the app, for instance? What is their contribution compared to your contribution? Of course, currently, right now, I think one of the main laws that we consider should apply to artificial intelligence applications is the data protection laws, because those ones are in place currently. And so the data protection laws, of course, govern how you share information with these platforms. They govern how those platforms use your information. And this is as much as you be able to control. But currently, right now, there's no specific way of telling between me and OpenAI who owns the IP. But definitely, when you create the app, of course, it's advisable that you immediately approach your registration services bureau, like URSB, like RDB, and try and also, depending on, of course, your specific laws, and see how you can register it.
Thank you, David. There is also a question that was addressed to you. To David, can the general court system also be used to better manage and resolve IP disputes? Haven't some landmark cases been decided so far in the IP arena? Looks like your argument is that the Uganda legal system is seen as not being an arena that is able to adequately handle such matters, which will be resolved mainly by arbitration. Just a quick comment as we move on.
Yes, that's also a very good question. I'm not saying that, of course, the court systems are completely incapable of handling. My approach is simply more of advice, considering how I've seen the different matters being handled and the expertise involved and the interest of the parties and how as well they are involved, testimony is being given, how evidence is being collected. More and more we understand that intellectual property is going to require a bit of diverting from the normal way we handle disputes. And because we haven't done this a lot in arbitration and ADR, I'm suggesting that we can as well look at that. Some of the main reasons that I'm promoting this, of course, is because of how long it would take you to get your judgment in relation to an IP matter, for instance, in Uganda, compared to how long it would be if you used arbitration. But definitely there's a lot of precedent, specifically regarding trademarks. There is enough of it. Where we are moving to, especially regarding technological advancements, there's going to be need for us to also explore new ways of resolving disputes.
Thank you very much, David. Bhumika, one question directed to you. Who is the real owner of the copyright in AI from the list given? The developer to persons, adding to creation, also can it be registered as a patent?
Yeah, I think that's a very good question, and that's where I think largely a lot of the jurisdictions, lawmakers, litigants are struggling to really answer that. If you visit my part of the presentation, I have talked about who really is the copyright owner. One is obviously it has to be a human. Secondly, it also depends a lot on what contractual rights exist between the AI system owner or the AI developer and the end user. So it depends on how the contract is framed, what policy or terms and conditions one signs up to when they are using AI systems. That's what determines the AI owner of the AI generated output. And in terms of can it be registered as patent, I think as is patents in common law, if you're able to prove that your AI system is indeed something novel, something unique, it may qualify as a patentable product. But for example, if you come up with a new neural structure altogether, which has not been used by anyone or configured by anyone in the market, those rules continue to apply in an AI framework as well. Otherwise, if it's a regular AI system, if it's an agent which is creating an app for you, I think the threshold is higher for patenting something of that sort.
Thank you very much, Bhumika. Considering the time that we have, I'll direct one final question to you, Bhumika. True, it is a time of AI or die. With bearing that in mind, how responsible do you think lawyers should make use of AI?
Again, I'll refer back to the segment that Andrea was taking. She emphasized that while these AI tools can be used just like that, AI tools as aiding lawyers, but I think what we bring to the table as lawyers, the unique perspective, or out of box thinking or diligence or the trust that our clients pose on us when they are engaging us, I think that should not go out of the equation at all. We can use AI as tools of productivity, as tools to better our work product, but complete reliance on only AI tools is something that would be deviation from our moral, ethical, and professional commitments as lawyers.
Thank you. David, any closing remarks as we wrap up?
Thank you very much. Yeah, the conversation around artificial intelligence and intellectual property is an interesting one, especially where we're going. I'm glad that we get to speak about it here. Again, if you are to consider the role of a lawyer as far as using AI responsibly is concerned, it starts with you yourself, your own ability to protect privacy of your own information, your client's information, and similar considerations. Artificial intelligence, of course, will definitely, we're seeing some new regulations coming about, like the European Union Artificial Intelligence Act. All these are interesting ways we're seeing how they apply to intellectual property is still, there's still a lot of room for growth. And it's going to be interesting to see where we go with it. Thank you very much.
Thank you very much to David and Bhumika for taking leads on the Q&A session, and to the rest of our speakers. Thank you very much for your insight, and to all our participants. I want to take this opportunity to express our appreciation for being part of this important dialogue. For the remaining questions, we'll share the emails for our presenters, and you can reach directly to them. And also we'll be sharing the slides for you to refer in a future conversation. Let's continue this conversation, build regional collaboration, and most importantly, put these ideas into action. Thank you, and I do wish you a wonderful day ahead.
Thanks, Glory.